Hello, my name is Dave Zapponi, and I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this community conversation, Human Resources Best Practices in HOAs. ECHO is a statewide nonprofit association established to support HOA boards and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. When hovering over the bottom of the screen, you will find icons you can use during the webinar. Use the chat feature for any technical issues. It can also be used to interact with other attendees and ECHO staff. If you have questions for the speaker, please use the Q&A icon. We will answer questions during the Q&A session at the end of the presentation. Due to the number of participants, we likely will not be able to answer all the questions during the scheduled Q&A time. However, we may have time to answer some of the questions in writing during the presentation. To help us select the most relevant questions for this audience, please use the thumbs up icon found in the Q&A screen. Simply click on the icon to vote for your favorite questions. Please keep your questions general in nature. Questions about specific situations are better answered one-on-one. Also, please be courteous and respectful of our online participants, including the speaker, staff, and sponsors. Any participant may be removed, blocked, or edited at the discretion of ECHO at any time and for any reason. Participants are solely responsible for their comments and actions. Except for sponsors, this program is not a marketing forum for professional service providers. This event is copyrighted by ECHO. We do not give permission to others to record the meeting in whole or in part. The whole program will be recorded. A copy of the recording and presentation slides will be emailed to registered participants within 7 days of the program. Please join me in thanking our program sponsors: the Kevin Boland Insurance Agency, HOME, and the Tinley Law Group, and our registration sponsor, Divergent Consulting. Now we will view 3 short videos from the Kevin Boland Insurance Agency, HOME, and the Tinley Law Group. Connor, please play the videos.
Hi everyone, my name is Kevin Boland, and thank you so much for taking your valuable time today to listen and learn at an ECHO educational event. You know, I joined ECHO about 5 years ago, and I really learned a lot. My acceleration was amazing because I listened to so many professionals like we are today going to talk about their specialty, and I learned a lot of best practices. So I'm really glad you're here today, and it's really an honor for me to be a sponsor and to give back to the association that really helped me. And I'm a bit of an old school guy at heart. I love to read books, magazines, and newspapers besides webinars. And one of my favorite journals to read is the ECHO Journal. I know a lot of you are aware of this journal, but for those of you that don't, please check this out. There's a lot of really good, useful, and easy to read information and great tips on here. So to help us become better board members. So I think that's it. Thank you, everyone. I hope you learned a lot today. And of course, as always, if you have any insurance questions, you can always reach me at kevinbolandinsurance.com.
Managing an HOA is no easy feat. That's why we built HOME. HOME is the ultimate financial and operational planning tool for HOA board members. HOME takes your reserve study data and brings it to life, allowing you to keep track of your building expenses and replacements, model different financial scenarios to better project the long-term health of your community, and turn your reserve study into actionable tasks, making it easier to execute for both board members and property managers. Sign up to get free early access to HOME at home.io.
Hello, and thank you for allowing me to introduce Tinley Law Group. We're an HOA law firm that's been representing homeowners associations for over 30 years. We love working with our client family over 1,000 communities in a wide variety of practice areas, including assessment collection. In fact, in 2013, we developed Altera Assessment Recovery, which is quickly becoming an industry leader in the area. Our Find HOA Law web library is also another example of our modern approach to adding value to our clients. We hope to have the opportunity to work with you and to develop a relationship with you and your community.
Thank you to all of our sponsors. And finally, our disclaimer. None of what is said during the seminar shall be construed as specific legal advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney. Our webinar today is Human Resource Best Practices in an HOA, presented by Jasmine Hale, Esquire, of the Birding While LLP. Ms. Hale is a veteran community association attorney with over 17 years of experience. She provides a wide variety of services, including governing document analysis, restatement of CC&Rs and bylaws, drafting legal opinions, conducting contract negotiations, guiding successful votes for the implementation of special and emergency assessments, coordinating capital improvement funding, and providing general counsel for all board governance. We are very pleased to have Jasmine here today as our faculty. At this time, I'd like to introduce Jasmine Hale. Jasmine?
Thanks so much, Dave. Really appreciate it. And thanks for having this topic. I know it's a pretty niche specific topic, and I really want to thank ECHO for, agreeing to host this. I talked with Dave earlier in the year and said, hey, this is a specialty that I have. I know it's not something all community associations that it applies, but I said, for those that it applies, I think this could be a really good fit for your organization. So definitely thanks to Dave, ECHO, and all the sponsors as well. So let's talk about the overview of what we're going to cover today. We're first going to go over just the common legal risks and employee challenges. I think it's important for us to set the stage on what is it that associations, like what are the risks that you have in having employees? Because I know a lot of times there's this push-pull between we should be managed by a third party and only have outside vendors because it lowers risk. With the pull of, hey, if we have these as our own vendors, not our own vendors, but our own employees, we have better control over the services that we're providing and that we're, receiving from our employees. How to respond to requests for reasonable accommodation. This is a huge source of liability. So understanding what they are, how to respond to them is really important for any employer, especially associations. And for those board members and GMs, you'll probably get a little corollary help on how do you respond to reasonable accommodation requests from your residents as well. And then we've got how to handle harassment investigations. I do these pretty frequently. It's not an inexpensive process, but it's certainly something that must be handled appropriately. So we're going to go over the practices on that. And then I'm going to end with best practices and recommendations. The whole goal of this is how do we lower your liability exposure and increase your organizational sort of satisfaction from your employees. So jumping right into our common legal risks. So we've got a bunch of different, I'll call them legal risks that associations have from their employees, whether it's, wage and hour claims. Wage and hour claim is probably one of the biggest sources that most employers have for liability exposure. And when I say wage and hour claim, what I mean is you either miscalculated the employee's pay. That's a violation. It's a statutory issue. You have to pay your employees the correct amount. The source where this really comes into play is when you're not paying appropriately for the meal breaks and for the rests and stuff like that. So, those are huge sources of liability. Also, when you improperly classify an employee. So let's say you're like, oh, they're an exempt employee. We don't pay them for their, meal and hour breaks. We're good. Well, if it's an improper classification, then you need to look and, identify the exposure for all of the lunch breaks, meal breaks, rest breaks that they should have been provided that didn't. I had a client come to me once and they said, well, this is an exempt employee, they're not covered. And I said, well, let me confirm that, because I don't want to just rely on an employer's sort of unilateral decision. And it was an assistant manager. And we went through what the assistant manager actually did. And it turned out that they were improperly classified. And, the financial exposure for wage and hour violations, it's not just you owe this employee the money that they were shortchanged. It's you owe them waiting penalties. And, it stacked up to, about a 6-figure issue because the person was improperly classified. So wage and hour claims are a huge source of liability. Then obviously just making sure that you're keeping up with the mandatory state, and if you're in jurisdictions where there's a county or a city wage increase, the objective is by 2025 for all of California. No, 2023. Sorry, COVID's kind of jacked with all of my timings. But by 2023, everybody in California will have a minimum wage of $15 an hour. Certain sizes of employers, if you've got 26 or more, you're going to get there faster. You'll get there by next year. So it's something to just make sure you're aware of. If you haven't already started adjusting your wages, you need to get there and adjust your budgets ASAP. So improper employee classifications, like I was saying, the push-pull between exempt versus non-exempt. And for board members, I think most people are familiar, but just a real quick primer. Exempt employees are exempt from the wage and hour, the meal requirements, the rest break requirements. So those are people who are paid on a set salary. Now, here's one of the interesting things. A lot of times a person will come, you land in my office because there's a legal challenge, and the association will say, oh, they're a salaried employee, and people, being salaried is not the same thing as being exempt or non-exempt. And so it's just a common misconception that a lot of people have, and don't fall into the trap. So a non-exempt employee is anyone who isn't exempt. So the way that you become exempt in California, there's been a lot of litigation and a lot of legislation over the last several years that's really, really honed it into, it's a job duties, straight up. You got job duties, you've got, do you make at least double the minimum wage for a full-time employee? So if you're an employer with 25 or less, it's about $54,000 a year. If you got 26 employees or less, it's $58,000 and change. So if your, exempt employees are not making those wages, they're not exempt, period. So that's a really important point to take into consideration. The next is job duties. And when I say job duties, it means that employees' time is primarily spent on the exempt work. So you could have a combo person who's like 30% non-exempt work, kind of manual or non-discretionary tasks, 70% discretionary tasks. That person could qualify as an exempt employee. And it matters, again, because it goes up to the wage and hour violations if you've misqualified someone. So one of the key components of establishing whether someone is appropriately an exempt employee is whether they have and routinely exercise the discretion and independent judgment. And that's not like, oh, well, I followed the policy that someone else created. That's, I had the discretion to do the job the way I saw fit to do it. And a lot of people at, below a manager or supervisor level are often misqualified or misclassified as exempt in those positions. And so I really do recommend that, associations, sometimes perform a workforce audit to just make sure that they do have the proper classifications. So there's like 4 or 5 different types of exemptions. You've got your executive, that's your GMs, your managers of your associations. They have management duties, they can hire and fire people, they have the judgment to do that, and they require 2 or more reports. Now, if you have like only one GM and there's no other employees, they're going to qualify as an executive. But if you had a person who only had 1 report, they're not going to qualify under the executive exemption. It does require 2. So then we've got the administrative exemption. This is a person who does office work. They are assisting in the executive's operation of the association. They execute special assignments. This is qualitatively related to the operation of the association. So that's what the administrative is. Sometimes, but again, not always, an assistant GM could fall under this administrative exemption test. We've got the professionals. Most associations aren't going to have this kind of an employee. These are folks who have licenses or other types of certifications, doctors, attorneys, accountants. Those are the types of professional certifications that fall under that exemption. And then we have computer professionals and sales personnel. Again, very rarely would that ever apply in an HOA's case, but those are the exemptions. And if you don't meet the duties of any one of those exemptions, plus the minimum salary test, plus the independent judgment, then you're non-exempt, period. And so just really keep that in mind. Next source of violation, or next source of liability, leave violations. I literally, my own firm had a question about this to me the other day, and they were like, so we have a person who's going to go on leave. Do we start with this and then we go with that? It's a whole complicated world, so I'm not going to dwell too far into it, but it's just to say that with leave violations, depending on the size of the employer, you could be governed by, the FMLA, that's the federal statute. You certainly be governed by what we'll call CIFRA, that's the California statute on leave. They provide, coverage for pregnancies on top of, temporary or lasting disabilities. The key with leaves is to provide paperwork when you first are aware of it, properly document when leaves start, and then, always go and make sure that you're referring back to your, workplace policies, your employee handbook, which suggests you should have one of those, of course. So other sources, we've got discrimination. Discrimination is, effectively a, discrimination and harassment. Those are kind of part and parcel of similar issues. The discrimination, some people will call it non-sexual harassment, is when you are discriminating or harassing a person for their membership in a protected class. In California, it's probably not a surprise, but we have a litany of protected classes, like far, far more than what the federal statutes do provide. So it's important that you understand them all. I literally wrote them down so that I could read them off, because it sometimes surprises people to be, whoa, that's like a lot of different categories. Like that's basically everybody maybe. You've got age, gender identity, genetic info, marital status, medical condition, medical or physical disabilities, pregnancy, that's its own, national origin, race, religion, sex, sexual orientation, veteran or military status. That is a lot of different classes of protected people. And the reason why that matters for discrimination / harassment is that if a person is experiencing negative job interactions or negative treatment at their job because of their membership in one of those categories of protected people, that is unlawful. The employer, the association, has a legal duty to actually investigate and take action. So it's a huge source of liability, because the liability doesn't just apply when the association actually knows, it also applies when the association should have known. And so it's, if you hear passing comments and you're like, ooh, like that one like made the hair on the back of my neck stand up, employers have a duty to step in those times. Sexual harassment is about unwanted communications or physical touches involving a sexual nature. A man, just the same as a female, can be sexually harassed. And sometimes that comes as a surprise to people. They're like, oh, I didn't think that was the case, but it actually is. The bottom line is on harassment, whether it's general harassment, the protected category, or sexual harassment, associations, all employers in California, must have a zero tolerance policy, like must. And the degree of liability exposure depends on who's doing the harassing. So you can be just as liable as an association, whether your employee is being harassed by a coworker, by a supervisor, or even by a vendor. And so that's why it's super, super important to have these policies in place so that you've got something to go over, when someone reports an incident or refers to an incident. So, these things require immediate corrective action. And that's really important because I think we can all appreciate in HOA world, we kind of turn at the pace of like a cruise ship. It does not turn quickly. It's kind of a slow process. And in employer world, the law really doesn't care if the board only meets once a quarter. If you have to take immediate and prompt action, that means schedule a special board meeting and get her done fast. So that's another source of liability exposure. Next, we've got retaliation. And I'm kind of going through and taking time to describe and explain what these are, because a lot of times these words are used. You're retaliating against me, hostile environment, and people don't actually understand like what that means. And I get clients who come to me freaked out like, hey, we got to claim a hostile environment. And you're like, well, let's just, pump the brakes and understand what the person is saying happened relative to what these things actually are. So retaliation does not mean an employer, an employee had a negative, performance review that they didn't like. Retaliation is when an employee is engaging in a protected activity. So say I filed my DFVH claim. I filed a claim against the association. I opposed the association engaging in a practice I thought was unlawful. They were going to have me apply, a chemical that I know is no longer allowed to be applied in California. I was, I'm a whistleblower and I turned in my HOA for, wage and hour violation claims. I was called to serve as a witness in a case for some other totally unrelated thing. I went to jury duty. These are all things that are lawfully allowed and protected activities. And if an association can someone or they do some sort of adverse job action against the employee for engaging in those activities, that's retaliation. Heck, even going to drug or alcohol rehab is a protected activity in California. So if you've got a drunk employee and they're like sloppy and falling on the job and then they go into rehab, you can't fire them for that. And that sometimes creates a lot of concern and issues with associations. So retaliation is, do I want to take a question or two during the presentation? I'm happy to take questions during the presentation, Dave. You just let me know. So one of the things that's important to understand is that retaliation is about prohibiting or doing something in an adverse manner to the employee who was engaging in a lawful activity. It doesn't matter if the engaging in the lawful activity may have negative implications for the association. It matters that they were allowed to engage in it in the first place. So that's just something to keep in mind. And then wrongful termination is another one. I hear this a lot. And this is simply when an employee is terminated for an unlawful reason. So they're terminated because I was an observant Muslim and I wore a, headscarf, and my employer refused to let me wear a headscarf. That would be wrongful termination. You'd have a whole lot of other issues as well. So it doesn't mean that a person who is in a protected class, one of those litany of classes that I outlined just a bit ago, can't be fired. That's not what this is. California is what we'll call an at-will state. It means you can be fired for any reason, just not an unlawful one. So it just means if you're going to terminate an employee or you're going to discipline an employee and they're in a protected class, you really need to document the file very carefully so that you can understand and demonstrate if they want to pursue some sort of legal or administrative action against the association, that it wasn't for discriminatory or unlawful purposes, that the adverse job action was because of substantive good business reasons. So on the next slide, we've just covered typical legal issues. Now we're going to talk about typical employee challenges. And these are, we'll say they're not legal issues so much as they are business issues that really do create risk and liability. So the kind of overarching umbrella that a lot of these different issues fall under is employee job satisfaction. And it's a huge issue. Right now we're in a weird time of being employers and sort of working in the world where they're calling it the Great Migration, where there's literally a constant movement of employees right now. I think the Department of Labor statistics said that the most people ever in the month of October left their jobs. And think about that. That's a big thing when employers lose employees and they go somewhere else. So the biggest issue, or one of the biggest issues with employee job satisfaction, these issues are all symptoms. Turnover. Turnover is when you've got an employer and they're going through employees, It's often a healthy sign of an organization when you're yeah, they have long-term employees, and as the needs grow, they hire more people. But if you've got a cycling through of employees, sometimes that can suggest turnover, and turnover can suggest employees who have, dissatisfaction with their jobs. Turnover is a risk. It's a liability issue for associations because they spend money training, they spend time and energy training, and it's destabilizing to the remaining employees when you have turnover. There's some positions that are just going to have more turnover than others, but you'd be surprised. You may think, oh, a valet parker, that's going to be someone who stays in a job for a year or two. I have clients in Los Angeles that have had valet parkers there for 25 years. So, it's because that's been a good employer and they have created a sense of purpose and a meaningful place of employment for their employees, including valet parkers. So turnover is one issue. We've got distraction, distraction can be anything when an employee isn't focusing on their job, this was 6 years ago. Facebook had over 800 million users. Today, Facebook has over 2 billion users. We've got Twitter, Instagram, LinkedIn, like and then I'm not even hip enough to know what all the new social media sites are. I know there's TikTok and Snapchat and you name it, but these are all sources of employee distraction. When an employee is distracted, it means they're not doing the business of the company, and that costs associations. It costs all employers money. So it's something that you just need to keep in mind. We all carry little, smartphones. Like, these are tiny little computers that are basically on everybody's, front pocket. That is a ginormous source of employer, wasted money paying employees to sit there and futz about on social media. I have had so many of my employers, and they have come to me and said, hey, we, still have common area video cameras in their lobbies and whatnot. And they'll say, hey, we've got our employees are literally sitting there for like 2-3 hours during a shift, and they're just on social media. Like, what should we do? And so, when I say it costs a lot of money for employers, it does. When you have people who are not actually doing the work that they're paid to do, it costs in more ways than one. So we've got consistency in attendance. This is an issue where someone just bails out on their schedule, or someone who shows up tardy. That costs the organization. I mean, obviously, you're not paying someone for, wages when they're not working, but it also costs the rest of your staff and your workforce, because they're having to pick up that slack while a person is late or, simply not showing up. It can create a lot of discord. I had a GM who contacted me, and she was at her wit's end. She said, I have this employee and he's been tardy or absent over the last year 50 times. And I was like, good Lord, woman, why didn't you take action sooner than 50 times? I mean, it was just really extraordinary. So calling in sick, unexpected departures. I mean, these are things that happen. So I'm not suggesting that every time an employee calls in sick, it means that they're a bad employee or they're not happy with their work. But when you start to see a pattern, it does suggest that this person has dissatisfaction with their job. And dissatisfaction with their job can eventually lead into, counterproductive outcomes for the association. Can also be toxic to the rest of the employees. Motivation, gossiping, gossiping can be a really, really catastrophic thing. I'm working on a severance agreement right now for a client. And one of the concerns that they came to me with in this process was, hey, this person that we have, separated from employment, they had a lot of good friends, we'll call them supporters in the community. And we're concerned that this person's going to continue engaging with, homeowners in the community who wanted this person to stay, even though they weren't a productive, employee in the workforce anymore. And so you can sit there and you say, that's a tough one to navigate. So you've got this gossiping component of, whisper campaigns in the community, and it can create a lot of paranoia with boards. It can create a lot of, conflict with existing employees. And so gossiping is something to be very mindful about, even though you can sit there and look at it like, seriously, gossiping? That's so high school. Why are we talking about this? And yet it's a big issue in a lot of separation agreements that I deal with. Motivation, when employees aren't really devoted to their jobs. And sometimes it's not evident, but a lot of times you can kind of see, you're like, you know what, 3 years ago, they were awesome. They were on the spot. They were, coming to me with ideas and, really put in an effort. And now they just sort of show up and I can barely get a smile out of them. These are all things that boards need to really, really take to heart, because the more these things occur and are left unaddressed, the bigger the liability exposure is. And the last, source of employee challenges is from owners, from board members, and other employees. I can't tell you what a tense industry this can be. I mean, all of you as board members, or if there's any, managers on this, I mean, we're on the front lines of getting a lot of abuse hurled at us at times. And it can be really, really challenging for employees in this industry, especially on the management end, to have to grapple with that kind of conflict. And it's something that associations ought to be mindful, our whole industry candidly ought to be mindful of the challenges that come from within our own industry, so that we can try and help our employees and help the people who are providing services in this industry to navigate that level of conflict. And so those are our typical employee challenges. So on the next slide, we're going to talk about reasonable accommodations. And I think a lot of people understand, like, oh, reasonable accommodations, that's that disability thing. And you're like, okay, one way to look at it. But let's really drill down into when an employee asks for a reasonable accommodation. And you'll kind of see, like, there's a logical order to my presentation. We just talked about employee challenges and things that create job dissatisfaction. A lot of those things lead employees to need to take leave to kind of just de-stress. I have dealt with so many leaves for stress-related purposes in this industry that I thought it was a helpful thing to go over reasonable accommodations. So what is a reasonable accommodation? If we didn't know, then it is a request by an employee who has a qualifying disability for an exception to an association employee policy or procedure or rule. So that's what a reasonable accommodation is. There has to be a connection, or what we'll call a nexus, between my disability and my accommodation. You can't say, oh, I have bad eyesight, I need a special desk chair. I mean, maybe there is a nexus between those two, but it's not just, oh, I have any disability, so I get any accommodation. There does need to be a direct connection between the two. So let's drill down into, how do we respond when we get one of these? Well, first of all, you need to understand that they don't have to come in through like a written request. It could be something you hear verbally. And that's something that a lot of employers and certainly board members don't always appreciate, is the same thing that applies with harassment that we just talked about also applies with reasonable accommodations. It's when you know or should know that an accommodation is needed, then the association has to go through its process. And so, you go to a question like, okay, so I have an employee and they've been out on medical leave, and they just sent a doctor's note that said they're not done. Their leave needs to be extended. You're like, well, they've already used up their 4 months of time. So do we have to agree to this? And you would sit there and say, the association needs to look at this and say, oh, this is a reasonable accommodation request. Even if the employee didn't ask for it, we have a duty to offer it. And so that's why there's so much risk for employers, especially on associations. I'm very, very mindful that the boards of directors are well-meaning people who are volunteering their time and serving their communities. That does not always mean that you are experts in HOA law and employment law. And so you can get a request for additional leave, and you're like, well, heck, we need this person back. We can't keep extending time. And so it's a challenge. So first off, when you know or should know that we're dealing with a request for a reasonable accommodation, so just a change to a policy, you've got to meet an executive session. Personnel issues are one of the things under the Davis-Sterling Act that you're allowed to actually meet an executive session for. Beyond that, there's lots of employee privacy laws that require you to keep their medical conditions and discussions private. Just as a little aside, even though requests for reasonable accommodation from a resident are not included under the executive session meeting allowances in Davis-Sterling, there's still applicable codes in California that say a reasonable accommodation request is supposed to be handled privately and confidentially. So reasonable accommodations, employees, residents, owners, you do them in executive session. First thing first, you got to confirm the employee has a disability and that it's something that's connected, it's related to what they're asking. So how do we go about determining that? You've got to request documentation. You don't request their medical file. I've seen some requests from, associations, and you're like, ooh, like that hurts my heart. We weren't supposed to ask for all of that. Normally it's going to come in the form of a letter. The letter just needs to identify like the nature and severity and the duration of the impairment, we'll call it. Sometimes it's a temporary thing. Technically, pregnancy can qualify as a disability. So it could be, hey, this person's pregnant. They need to work from home for the next 3 months. That's an accommodation. The letter needs to address the nature of the impairment and how it limits the employee's ability to perform their job fully. So basically, what is the requested accommodation? And then lastly, you need the letter to identify what's the nexus, what's the connection between disability over here and the accommodation over here. In very, very limited circumstances, the employer, so the association, could actually ask for their own preferred physician or their own medical provider to do an examination of an employee. If you're like anywhere near that realm, please talk to your attorney first before you do that, because there's a lot of risk in saying, hey, we want to evaluate you and check you out to make sure that you do have a disability. And it goes without saying, whether it's an employee or a resident, when the disability is open and obvious, so let's say it's a blind person or it's a person with, hearing impairment or some sort of mobility challenge, you don't get to ask for further documentation. If it's clear that, what they're asking for, like, hey, I need you to add a ramp or a railing or something to the effect. You don't get to ask for the doctor's note on those ones. But when it's not open and obvious, you do have a right to ask for documentation. And, I take the position, it's actually important to get the documentation so that you have something in your file that says it was appropriate if we gave a reasonable accommodation request. So when to grant them? Well, if the request for the accommodation or the exception is reasonable, then you must grant it. That's easy. It's who pays for the accommodation? The employer pays. So there's that. So what is reasonable? The way I'll explain that is it's something that we look at and say, is what they're asking for fall into the unreasonable category? And I know you're like, oh my God, of course, lawyers, they don't answer things directly. They say what things aren't. And I guess the way to look at that is that's the law's way of saying most things are going to fall in the realm of reasonable. So it's kind of presumed to be reasonable, and the employer has the duty to say, oh, what they've asked for is unreasonable. And unreasonable is something that causes undue hardship, or it causes us to fundamentally alter the business that we do. So, to Dave's question that he just posed, who pays? Just because an accommodation is going to cost an association money does not mean it's unreasonable. And a lot of associations are like, hey, if I have to buy $1,000 desk chair so this person can sit and do their job, that's not reasonable. That's expensive. Well, financial considerations are certainly something that can be factored into the when to deny, but that's not the end all of the discussion. Here's some examples of things that have been considered by courts as reasonable. Holding a person's job open on an sort of an indefinite, I mean, the law is very clear, you don't have to keep it indefinitely, but we'll say extension after extension beyond what the law already provided. That's a reasonable accommodation. It could be allowing someone to bring in a pet, could be modifying their work schedule, having them change jobs. Those are all things that have been qualified as reasonable. And providing additional leave as a reasonable accommodation can become tricky. I'm literally in another, matter with an employer association client where it became unreasonable for the board to continue allowing additional leave. And they said this was an integral person to our organization, and we've had months and months so far without this important person. And, then you get to the question where you say, okay, well, how have we documented the undue hardship? And the factors that go into undue hardships, so that's on the when to deny one, are things like, how much is this costing the association? So if you're not paying someone because they're not there, and you're like, all right, well, it's actually not costing us money in terms of salary, but maybe you had to bring in a temporary person, and that temporary person's wage is much higher because you're going through a staffing agency or something to that effect. So you could say, hey, we only had X amount in the budget, and now we're way past that. We financially cannot continue to sustain this. So the financial wherewithal of the association does matter actually quite a bit. And that's something when clients come to me, I'll evaluate. Dave asked, is bringing a baby or a child to work reasonable? And reasonable or undue hardship are super, super fact intensive. It is possible that it could qualify. On the other hand, you may sit there and say, it requires a fundamental change in our operations. I've worked with an employer who had to convert a closet where servers used to be and weren't anymore. They had to convert it into a lactation room for a employee so that she could, appropriately, handle breast milk. I mean, these are real life examples, and they're not easy to just analyze and give an answer off the spot, because you have to sit there and identify, well, is there anyone else in the room, to the question of, is bringing a child a reasonable accommodation? The biggest thing, the what happens next, that's your interactive process. It's called the interactive good faith process. And that's effectively a back and forth. It's like a volleyball game or tennis match. And it's basically a dialogue between the requesting employee and the employer, the association, where, let's say it's Dave's example. Hey, I need to bring my kid to work. You're like, all right. Why? It could be, I have a medical issue and they're helping me. I mean, who knows the why? Maybe the kid has a medical issue and I need to administer medication and I don't have any childcare options. You sit there and say, oh, okay, maybe in that case, bringing the child to work isn't the accommodation. It's allowing the person to work at home. That's the accommodation. But let's say it's your maintenance person, your facilities manager. You sit there and say, well, this person literally has to work on site. That's the whole point of this. You can't really, check boilers and pipe leaks if you're not physically here. So that could be well, no, that's not reasonable. So just appreciate that the undue hardship analysis it's incredibly fact specific, and it has to be addressed document. I mean, and when you think you've documented, document some more. And the reason why is that I get a lot of my clients that'll come to me and say, oh, well, we've been offering reasonable accommodations. I'll say, well, where's the correspondence? And they'll say, oh, well, we had all of these discussions. And you're like, okay, I can't, it's hard for me to prove that in court, because you'd be amazed at what memories change by the time you get into a legal battle. They're like, oh, they never offered me those things. And I'll have managers are like, what are you talking about? Like, I did these things. And so one of my recommendations when we're in a reasonable accommodation process is to ask, even if you're having these verbal discussions, and that's a human way to interact with someone. I certainly support that. Make sure they understand, hey, we're going to follow up just so we have this for our records with a written communication afterwards. So, hey, I'm manager so-and-so. I'm going to, put my, I'm going to put this in an email so we've got a record of this, because there's an axiom among employment attorneys. It says the last person to respond to the interactive process is the person who wins the battle. So for the associations, let's win the battle and make sure we are always responding and documenting. And, what happens when a request for reasonable accommodation is rejected and the association says, hey, we've documented all of these reasons for undue hardship. We can't financially afford it. It far exceeded our budget. Requires us to fundamentally change certain things that we can't do. Maybe, hey, we felt that this was unsafe for our other employees. There are reasons for rejecting the accommodations, and you've gone through the interactive process. Something you can do while you're in the process is offer whatever accommodation the board can offer. That's helpful to say, hey, we didn't just say no, and then that was the end of our discussion. We said we could allow X while we were considering their official request. But at the end of that road, the next step is for them to, pursue legal action. Hopefully it doesn't happen, but that's the end of that road. So that's reasonable accommodations. Little sort of unrelated, but kind of corollary on next slide with harassment investigations is these are other types of issues that boards certainly come across. I can't tell you how many harassment investigations I have done this year. That should give you an example, that should give you a small understanding of oh, this happens kind of frequently. So what's a harassment investigation? Again, when the association knows or should have known that someone was being, subject to, we'll call it abuse or some kind of, adverse issues in their employment. Let's say they're being picked on by a colleague. The association should actually look into what is going on and not just be like, that's Myrtle being Myrtle. She's just kind of a cow. And you know what I mean? I get these comments from boards kind of frequently well, everybody knows that person's just kind of caustic and not really nice, but they're good at their job. And, what do you want us to do about it? And you're like, well, investigate it. So let's talk about what is what is a harassment investigation? First and foremost, California employers must have a written anti-harassment policy. Full stop. If you don't have an employee handbook, you need to have one. You at least need to have a harassment policy. It's the law. On top of having a written policy, as of 2 years ago, California employers with 5 or more employees have to also provide, anti-harassment training to their employees. 1 hour for all the normal employees, 2 hours for your supervisors and your managers. I would suggest, and I know this will probably cause a lot of consternation, board members may be well served also doing the 2-hour harassment training video. I know that is the last thing that you guys want to do as volunteer homeowner board members. but it still helps lower your association's liability if you can say, hey, we did our video. We sat there and we watched a video at the beginning of one of our board meetings once. We're taken care of. It lasts 2 years, and then you repeat the cycle, rinse, repeat. So there we go. Who conducts the investigation? That's a business decision for the board of directors to make. Depends on who's being, complained about. If your GM is the person that's making a complaint, the board could be the investigating policy, the investigator, they could designate a director, a specific person. They could hire legal counsel. If you had an HR person, some associations are like, what? Other associations have like very large staffs, and that's a position they actually have. So who does the investigation is absolutely a business decision. I would just caution the board that you select someone who is comfortable with doing an investigation and qualified. If you cannot have a person who is being complained about do an investigation. So be careful with that. Next, we've got, the how to do an investigation. This is the part where a lot of boards get tripped up. You don't necessarily conduct your investigations on site. Rather, you should conduct the investigation where the person who's being interviewed is going to be comfortable. A lot of times it's actually going to be off-site. I had a client in the Central Coast area, and very, very large community, large area. And they had a harassment report filed, and it was about the GM. So that had its own level of complexity. And so, we had to sit there and identify where the employees were comfortable coming and giving, kind of open, unrestrained commentary on their, what they've seen and witnessed. And so most of the interviews occurred off-site. Hauling them into legal counsel's office is also intimidating for a lot of people. And so I've learned over the years, you ask them, where are you comfortable to meet with me? Before Zoom and COVID, I probably would not have done very many investigation interviews by Zoom or over the phone. It's certainly changed over the last 2 years. My preference is still to do these things in person. There's just a human connection. So it's, take that into consideration. You ask open-ended questions. You never, ever record these interviews. Literally had one of my clients who had he called it like a compliance officer who did investigations. He literally had a body camera on him and would do workplace investigations. And I was like, oh my God, no, that's so wrong on so many levels. So don't record. I start my interviews with the same set of, we'll call them admonitions, like rules of the road, to say, hey guys, this is just so all of you know, the same interview process that you're going through is the same process that everyone connected with this is going to go through. It helps to make sure that my process, my investigations, the association's outcomes are less challengeable, if you will. I actually type my questions before I even show up. And then I write in responses. I have the person that I'm interviewing actually read through my responses on the spot and sign them. And the reason for that is so that I can sit there and say, I correctly heard what they intended to communicate to me. And the reason why that matters is you don't want someone to challenge the outcome of a harassment investigation and say, well, she didn't hear me right, or she screwed up what I said. That's not what I meant to say. So it's a helpful just circle back on my end to say, hey, this is what I wrote down. Are we clear? It's sometimes people can be taken aback, but I explain why it's some part of my process, and I've never had an issue. And then, at a minimum, when you're doing a harassment investigation, you need to talk to the person who's complaining. You need to talk to the person who they're complaining about. And if they identify other people who have witnessed or seen or heard things, then it becomes more of a discretionary thing. I have had people who have said, oh, you need to talk to this person. And I have elected not to do so because I've read communications or I've heard in interviews that they have a straight bias against one of the parties. And, as the investigator, part of this is, my responsibility. The goal of an investigation is not to prove or disprove anything. It's to identify the facts of what happened. And, if you can sit there and, evidence that gets provided to you before an investigation starts and you're like, yeah, this person straight up hates this other person. Sometimes it's not practical or meaningful to interview someone is already biased. So that's the how to conduct the investigation. And I think it's worth noting, and I'll move this along, but I think it's worth noting that bullying is not unlawful. I have had so many complaints arrive at my desk, say, we need a workplace investigation. They'll use words hostile environment, but what they mean is I've got a board member or I've got a manager, a supervisor who's bullying me and being a jerk. Like, being a jerk is not, you can sit there and debate the morality of it, but it's not unlawful in California. But just because it's not unlawful doesn't mean it's not harmful. The last investigation, or one of the last investigations that I did a couple months ago, was about bullying. They initially reported it as something different, but it came down to it was about a person who felt they were being, substantially bullied by a director. And, it created a lot of issues. And like, the last thing HOAs want to do is spend a bunch of money on a lawyer to come down at the end of it and be like, oh yeah, this person was bullying this employee and it's created a lot of big feelings and they now hate their job. But that was the outcome of one of the investigations. And so why this matters is the report and the actions that you follow up on. So when I prepare a report, they're comprehensive. That's so my clients have a really strong grounds to say the actions that we took were recommended and they were based on findings and best practices. But things that go in a report or that can go in a report are, who did you interview? Like, how long were the interviews? What are the laws or the policies that are at issue here? What are the allegations? Like, what are the findings? That's the whole point of an investigation, is to establish findings. Like, allegation X, finding, did it or did it not occur? Or I can't conclude one way or another. Those are all types of things that go into harassment investigation reports. But the most important part to me is the follow-ups. In my recent investigation that was really about bullying, even though there was like no unlawful activity that occurred there, I still had a litany of recommendations for the association to implement so that they could try to lower the stress level that this employee was being confronted with and help increase her job satisfaction, help to support her, and to avoid this from happening to other employees. And happily, the client did take the recommendations and implement them. So that's harassment investigations. I could spend like a whole hour or two on these alone, but that's a good nutshell for boards and managers to understand, like, how do we handle harassment investigations? So on the next slide, we're going to talk about best practices. And first and foremost, have an employee handbook. Oh my word, it kills me when I come across an association. Even if you've got one employee, have a handbook. I just talked to you 2 slides ago that anti-harassment policy is legally required, but handbooks help protect you. These are best practices to lower your risk and liability exposure. And beyond just having a handbook, have it updated periodically. Aside from all of the laws that constantly change for HOAs, we have that same level of legislative and case law changes for employment law. And so as you should have a tune-up every once in a while. how to conduct employee reviews. It's interesting. There was a study by SHRM, that's like the Society of Human Resource Managers, and they basically do a lot of, employment related advocacy and information. And they did a study and found that annual reviews, so only meeting with an employee once a year to review performance, those are declining in popularity. 82% of employers in 2016 preferred them. 3 years later, 2019, that had lowered to 54%. So, what's in its place? Providing performance reviews when it's needed. Giving real-time feedback is a best practice, but if you're not equipped, and certainly I appreciate associations, like it's not the same thing as a company that manufactures widgets or provides law services, so at least annually. The most important thing with employee reviews is they need to be honest. Oh, heavens. I can't tell you how many times I'll get a person and they say, oh, we need to terminate this person. Terrible employee, just terrible. Really creating a lot of issues. Let's say, send over the personnel file. I get it. And I'm like, oh, crap. They've had 20 years of excellent and very positive performance reviews. And I really am going to have a hard time litigating this and protecting you, because it's going to look like you're, terminating them for one of the various unlawful things that I've covered earlier in this session. So be honest, even when it's uncomfortable. That doesn't mean you have to be mean-spirited in your communication and what you're conveying if the person isn't living up to, the expectations of the association. Sometimes providing the positive stuff first is a helpful way to sort of prime the pump, and then go into, well, so here's some things that the association would like to see changed. And so that's a softer way of saying we don't like what you do. But being clear and constructive and then documenting those things is really, really critical. So that when it comes to me, I don't tell you, well, you're probably like a year out from being able to successfully terminate this person because you don't have the documents to support a termination for cause today, even if you believe you do. An important thing with employee reviews, follow up, check in with them after you've given them feedback and make sure they're either on track and they know that, or if they're still not there, keep giving them further support. Solicit feedback from your employees. Ask them, hey, what could we do different? It's a two-way street. And that's something that's important that all employers, but certainly associations, take to heart. Insurance review. It's something called Employee Practices Liability Insurance. And if you guys have it, wonderful. You guys get gold stars for the day. But so many of my associations do not have this coverage. And if this is the most beneficial thing that I say all day, then talk to your broker about having the policy. It's not your workers' compensation policy. It's the policy that covers all the scary things that I've just talked about for the last hour. It covers your discrimination claims, your wage and hour claims. It covers your retaliation, wrongful discharge. All of those things are covered by an EPL policy. So it's really important that you at least investigate it and build it into your budget. These policies are often not super expensive, and they provide you an enormous amount of protection, because the flip side is you're footing the bill for your legal fees up front, because they're not going to be covered most of the time by a D&O policy, and certainly not through your general liability policy. And there's like no downside for employees to pursue legal claims against their employers. I mean, you got to understand, like, the plaintiff side of employment disputes, they do things on contingency. So your employee's not like shelling out money to hire an attorney to pursue a claim against you. And so it's just really important that the association has its own ability to respond and protect itself, so that you're not funding, my costs out of pocket to help defend you. And then the last thing here is engage legal counsel sooner than later. This is not me trying to drum up business, good Lord. I am swamped, but it is to say, I can't help defend if I'm already 8 steps behind the 8 ball. And sometimes penny wise and pound foolish is definitely not the best practice on how to engage with employee and employee challenges. And on the last slide for recommendations, this is how to sort of improve the organization so that we minimize claims from happening in the first place. If the last slide was about lowering liability exposure, this is about proactive steps that we can take to effectively improve job satisfaction, lower the potential that claims are ever brought. Focus on building a positive organization and, creating positive employee morale. How do we do that? Like, show employees that you appreciate them. I mean, that sounds so small, but it's something that can be so hugely meaningful. There are survey after survey, 53%, there's a Glassdoor survey last year that said if their employer simply showed them more appreciation, they would stay longer. They said employee turnover in like the first slide is a big risk, and it's a challenge, and it's an issue for associations and all employers. So simply just saying, hey, you're doing great, can really like help an employee stay longer. That's not hard. One of my workplace investigation outcomes that I did for an association, I realized one of the things that the association's employees were missing was actually feeling respected by the management. And I said, hey, you should implement a periodic like employee appreciation lunch. And it worked wonders. And you can sit there and say, we're buying them off with pizza. Yes, if pizza is what's going to help make your employees feel valued and respected, it's something that's worthwhile to consider. Pay employees fairly. I know a lot of associations will sit there and say, hey, it's dues, well, the reality is you need to pay your employees what the market's able to pay, and to just do a periodic, salary or wage audit to find out if the pay needs to increase relative to, the industry. Invest in systems. It's in the board's control. You guys control the purse strings and the budget. And so if there are systems that can help make your employees more efficient or their jobs more desirable and more enjoyable to do, consider investing in those. It's a wonderfully powerful gesture and demonstration to your employees that says, you guys matter to us and your job satisfaction matters. I had a association that had a full-time person who was there to like fix broken equipment, and it's a big association. And so they got a new GM, and she came in, and I love her and she's great. And she was like, so how much money are we spending on person X? And how much money are we spending on, like, they constantly fix the broken trucks and stuff like that? And she was like, so if we just buy a new truck, we can basically take this person and put them in an entirely different department and save our things. And yes, I can. And so, that was wonderfully efficient. And so I just so strongly recommend evaluate what your needs are, what your employees' needs are, and then try where the budget allows to marry those two so that they're not trapped in this unsatisfying, frustrating job experience. And the association can be more efficient. Sometimes it actually does result in reduction of staffing because you're able to be more efficient. Training, train. Oh my heavens. Management training, go get certifications, CACM or CAI. Those are both great organizations, but those aren't the only folks in an organization who can be credentialed and certified. You have a whole boatload of different employees, and associations should show that they value their employees and go and invest in their training. You may have a supervisor, a building maintenance person or a landscaping person. Say, hey, why don't you go get your chemical certification? Or, hey, why don't you go get your boiler certification? And it's something that I think is helpful for the association to do on like the technical aspects, certainly ECHO, they provide lots of, education and training. And so this is just to say where training is available, I really recommend that boards adjust their thinking and understand that it's worthwhile to invest in your employees and to say, hey, you need that boiler certification, we're going to pay for you to do that. It helps them stay longer and you get all the benefit of that increased knowledge. And then lastly, but certainly not leastly, create stability for your employees. A 2020 American Psychological Association study showed that 78% of people feel regularly stressed out at their jobs. Like, COVID has been this incredibly destabilizing sort of national, local, world event. But when we're talking about 80% of the workforce feels sort of unnecessarily stressed at their jobs, whatever employers can do, associations included, to try and help create stability for their employees. I'm not sitting there and telling you to go tell your employees like, hey, you've got a job here for the long run, because that's a no-no. But I am trying to say that creating an atmosphere where your employers not only feel valued and respected, they feel that they are, important to the organization, but they feel that there is stability. It helps lower that stress level, which helps lower medical leaves, absences, and all of the negative things that we've been talking about. So those are just some recommendations. These are practical things that are within board's authority and within your capabilities to, sort of put in and, try and, make your organization the absolute best that it can be, because I think you'll see that it also improves in owner satisfaction, and that's a helpful thing. So that is the presentation. I'm happy to take on questions, answers. You just lay it at me.
Great. Let's lay it at her. Thank you so much, Jasmine. That was really great. So now we're going to go into the Q&A session. Just a quick reminder to use the Q&A feature. And what I'd like you to do is at this time, to go and vote for your favorite question. And there's a whole bunch of them in there. We have 12 questions, and we'll start from the top, the one that gets the most votes, and we'll just work our way down. And that'd be really a good thing to do. One quick question, Jasmine, while they're doing the voting. EPLI, what does that stand for? Employer Practices Liability Insurance. Okay, so you're going to want to have that in your HOAs. Another quick question, workers' compensation insurance. We have a lot of contractors that come in, and there's a lot of issues that happen there. Should they have workers' compensation even if they don't have employees?
Every single association should, absolutely. And here's why. Is a really, really good question. So let's say that you have a vendor and they said, oh yeah, we're licensed, but you didn't check their license. Or let's say their license has expired and now they're not licensed. Technically, an unlicensed vendor, like a handyman who falls and breaks a wrist or whatever, that's under the law, that's considered an HOA employee. And so you would, regardless of whether you have work comp coverage or not, you would still be responsible for their workers' compensation, damages. And so every single association should absolutely have work comp. Heck, this is another little tidbit for all of your individual board members. All of you on your own homeowners associations policies should also have a workers' compensation rider. It's like $2 a year. So it's not like it's a lot of money to pay for the rider, but same thing. If I'm sure she doesn't have a license, but if my housekeeper, rolls an ankle and gets hurt in my home, I am her employer and I actually owe her workers' compensation.
So that's a good one. So that it doesn't seem like you need it at sometimes, but the fact of the matter is that even if you're not actually paying them, you're liable. So let's talk about question number, the first one with the 5 votes here. How do you handle a hostile homeowner who harasses an employee?
Billy clubs and back alleys are not the answer.
You can say, I can say that.
So you go through the investigation, and this is something that I have actually had come up many occasions where it's a homeowner, and the tough thing with that is it's not like you can necessarily make the homeowner move, because they have their own legal right to be there, but it does help the association to appropriately document if you're going to start taking, we'll say actions like disciplinary actions. Maybe you call them in and start imposing fines. Maybe you suspend their common area privileges so they can't go and use amenities. Maybe you have to go and obtain a what's called a workplace violence restraining order. Employers, so associations, can go get those on behalf of their employees, and sometimes it's actually merited. I had a client that I had to go and get one. His little monster children were driving their golf carts all over the community and kind of like creating a lot of havoc. And maybe I could be like, what's that hard? Like, they're driving golf carts, whatever. But it was really creating a lot of issues in the community. And it was because they were like 10-year-olds operating them in an unsafe manner. And so the little kids would go and tell things to the parents and be like, they called us fat, or they called us little whatevers. And so the dad shows up one day and threatens to kill one of the security officers. Yeah, it was serious. The security officer freaked out and was like, because it wasn't like he showed up in a station wagon and was like, hey, I'll kill you. He literally pulled up, like went into the security guard stand and was like, I'm a member of a biker gang, and it sure be, it was really sinister. And so we went in and hauled him into court and got a restraining order.
That's crazy. With respect to that, a lot of times we get the volunteer board members, they have factions that are harassing each other.
Sure.
And you just answered a really good question, but should there be rules that specifically say what it needs to be, what needs to happen, what a harassment is, defining it?
Sure, that's a very good question. So there are definitely some clients where I have had the association go through a rule adoption process. So I think I'll make it clear here. Normally, employers, if you're going to adopt a policy, you just adopt the policy. You don't have to go through a standard like operating rule adoption process, the 28 days notice to the membership and all of that. But there definitely have been some of my clients where I've said, hey, board, I recommend that you adopt through the rule adoption process a anti-harassment policy that not only covers your employees, but also covers your homeowners and your residents. And it goes into these very questions, what is harassment? What are we going to do when we learn that this is happening? What are, enforcement options? So it's definitely something I've done.
Okay, that sounds good. Let's take a look at Brian Didier's question here. Is an assistant manager due mileage reimbursement if he is an hourly employee? How about if he rides a moped scooter to the Home Depot to pick up a small item? So mileage reimbursements.
Those are pretty specific, but generally speaking, if an employer has an employee go and do tasks, the employee is, should be compensated or reimbursed for their mileage. So the Home Depot runs, whether they're on a moped or driving a Honda Accord, both would qualify. It's not the type of vehicle that's driven, it's the fact that they drove their own vehicle for a operational purpose.
Okay, looks like Dave's having a little bit of an issue. We have another question from Brian. Is it necessary to terminate a part-time hourly employee? Can we simply reduce or eliminate their hour schedules?
again, generally speaking, this is a at-will state. So if you no longer have an organizational need for an employee, you can certainly identify, it's not cool to ghost someone. Like if, if they're an employee and then one day they're just not on the schedule and you've never told them like, oh, by the way, we're not putting you back on the schedule. I mean, that's just like, that's not appropriate to do. You can certainly communicate to the employee like, hey, our organization, we're simply going to be eliminating the position. It's not about you. It's just the position is, no longer needed or whatever. I mean, that's an appropriate dialogue to have, because you don't want to like leave someone flapping in the wind where they're like, I'm their employee. I'm just not on the schedule today.
Got it. That's a good common answer for that one. The next question is we have from Penny Carter. What is the importance of having a detailed job description? Is it important for employees working within the job description duties? What if they are handling matters outside of their job description and it causes a liability issue to the HOA?
Okay, great question. So the benefit or the reason why we have detailed job descriptions is on the front end so that you and the employee know if they're appropriately matched to the position. You know what I mean? Like you don't want to hire someone who has qualifications 1, 2, 3 if the job description really requires 5, 6, 7. You know what I mean? So it's important that you understand what does this position need, so that you can make sure and hire correctly at the front end of this. On the back side of things, when an employee isn't following the job description, they're not meeting the things that they're supposed to do, it helps the employer to, have a reasonable business basis for a termination or some sort of, adverse job action.
Okay, thank you for that. Let's see here. We have anonymous attendee. If an HOA decides to have a professional management organization run the affairs of the HOA, how do you protect yourself from potential lawsuits from your current property manager? So it looks like it's moving from a on-site or a manager like that to a managed association.
Sure. Well, so generally speaking, again, that's kind of to the question that was just asked. Hey, how do we, stop with the part-time person? You're like, okay, well, we've made a business decision that we're changing our operation, our operational, structure, and boards have the ability to do that. Certainly there's a lot of best practices that boards in those situations can talk about before they get to the point of saying, we're going to be terminating you. Because even if the board has these great business, rationale for it, there's always risk. You could sit there and say, oh, they went to professional management, not because they thought it was a better idea, but because they are discriminating against me. I'm a 45-year-old woman and they thought I was too expensive or whatever. So I would always document the file beforehand, like supporting, hey, if it's about costs, that the association has done that due diligence in advance. So, if an employee wants to come back and say it was improper purposes why you moved from me to a professional management company, the board has those at the ready and says, well, we did the due diligence and these are the rationale we have, and here's the things that support that rationale.
Perfect. Thank you for that.
Okay. So here's the next question. How should emotional abuse, lies, and gossips from a group of condo residents, one is a board of director, toward a single resident be dealt with?
Billy clubs and back alleys, my friends. Totally kidding. Again, we go back to the how to handle a harassment investigation, first you need to identify what kind of harassment is occurring. Is it the unlawful kind where it's, because of a protected class, or it's a sexual harassment, or is it bullying and abuse? And if it's just general bullying and abuse, then the association can identify types of things that are within its control, whether that's saying, hey, send a cease and desist letter to a bullying and abusive homeowner that says, we're not authorizing you to speak to our manager anymore, or we're not authorizing you to speak to the director at issue, impose fines or privilege suspensions. There are definitely options, but you need to go through the proper process to sort of take those.
So what do you do in the case of them being a protected class? How do you walk on those eggshells when it's really about an issue that maybe there is a change or a legitimate reason, and they're suggesting that they're maybe a protected class?
Well, that's why I said, the due diligence that a board can do so that they're going to take an action, front load with due diligence so that you can support, like, this isn't about you being in a protected class. This is about these legitimate business reasons. So if it's an adverse, job action, and you're saying, hey, this isn't because this person is, a racial minority, or, an ethnic or religious, an observant religious person. This is the performance that goes back to like job duties. Here's the job duties. They're not meeting them. Or here's our employee handbook. Here's all of these like conduct expectations. They're not meeting them. So having policies allows HOAs to do those things instead of flapping in the wind and being like, well, we don't have anything in place, but we don't like what you're doing. The thing they get to hold their hat on is protected class, protected class, protected class.
Mm-hmm. Well, I see that especially with the aging population. You might have a staff member that's, up in the 50s, 60s, 70s years old, and they just don't understand technologies and all the new systems. And so I think that's a fairly decent challenge, especially if you have a young person that's working part-time or something that may know something more about, how to do.
But it's also, that goes to my, recommendations and best practices at the end of the presentation, which is consider training the employee who may be lacking in technical skills, and give them that opportunity to say, hey, you've been here for 20 years and we value the institutional knowledge that you have and the familiarity with our systems. We do need for you to improve in these areas, invest in that person. Now, it could be that you have done the investment and you're like, yeah, that's a rock that we can't keep rolling uphill. But at least then the association can demonstrate, like, we didn't just cut and run. We took all the steps that were reasonably in our power.
Mm-hmm. And how how much time does that take? How far do you have to go?
It's fact sensitive. So it's not like well, if you've done 2 months worth of X, then you're good to go. It's more about evaluating things through the lens of, has the association acted reasonably? Reasonably meaning, you're not bankrupting the association, like putting people through college. That's not what this is about. Mm-hmm. And then documenting the file to demonstrate, that you've upheld your policies, that you have acted consistently amongst employees, and et cetera.
Okay, so here's, so let me just tell the audience that Jasmine has graciously agreed to go beyond the time, and we've already gone beyond the time of the seminar. So if you want to leave, that's fine, but we will be answering some more questions for maybe another 5 or 10 minutes. And we'll just go on through. We have quite a few questions here that need to be answered. This should be answered. It's been great having you here, Jasmine, to do this, and we appreciate your time. We have 2 or 3 direct employed staff in our HOA. With only 2 staff, do some of the laws not apply to us? And how small? Can you talk a little bit about the size of the company and what applies to a 2-person staff versus a 5-person staff or a 25-person staff?
Sure. No, it's a good question. So things changed with respect to leave and the amount of leave that an employer has to provide. And when I say the amount of leave that an employer has to provide, I'm not talking paid leave, I'm talking unpaid leave where you have to keep that person's job open for them. And so I have to go through, like, I just finished the new law update, all the statutes and cases for the HOA stuff. So now I have to go and review that for all of the employment law stuff. But I do believe that the law was actually changed this year to modify so that, you know, leave applies, whether you're 5 or, you know, 2. Certainly things like the sexual harassment training that kicks in at 5 employees. So there's a lot of different statutes. It's like far beyond this presentation to cover all of them, but the takeaway that board should hear is that you still have a lot of risk, whether you have 2 employees or 30. And so it's implementing these best practices, the ones that apply, to help lower your risk, because 2 employees is still 2 sources of liability.
Okay, that sounds good. Appreciate that. And so, you know, I think the main point is that there's the size does matter in this case. If you have a lot of employees, it's different than if you have, you know, 1 or 2. And so that's important to understand that. And then ask counsel. You know, really, you need to get a professional that knows this stuff to give you some guidance and design the rules. Is there a general definition for what a hostile work environment is? Is there something out there that she can refer to?
Sure. A hostile environment is, I'll describe it this way. It's when an employee it's effectively retaliation. They're kind of used synonymously. It's when an employee is engaging in protected activities and they are being discriminated against for engaging in the protected activities, or it's when the employee is, you know, in a protected class and they are, you know, being discriminated against for being in the protected class. It's harassment. So there's not like a legal definition of hostile environment. It's a kind of amalgamation of these other, we'll call legal issues are, but the term that a lot of people will say is hostile environment.
Okay, it's a buzzword, right? So yeah. Okay. How should emotional abuse, lies, and gossip from the group and accountability be dealt with? I think we talked about that one. Harassment complaints should be clarified. Our GM calls every criticism, every issue owners. He calls it all harassment. That's how he threatens the owners to complain about his poor performance. How do you deal with something like that when the GM is adopt a proper employee handbook with a anti-harassment policy that addresses, here's what harassment is. You know, if it's bullying and issues, here's our open door policy. We're going to allow you to provide your criticisms, but then it also gives the board that cover to say, Bill, you know, we understand that you take personal umbrage with respect to criticisms, but there's a difference between criticism and harassment. And you know, the board should manage that situation. If the GM or whoever isn't performing well, then having that handbook with, you know, job descriptions and duties and performance expectations helps the board say, this is what you're supposed to do, and these criticisms fit with the things you're not. Mm-hmm. Well, and I think some of the times the harassment, there are various different ways that harassment It comes through the homeowner to the board member to the employee, homeowner to an employee, and getting the board motivated to do that, to do some enforcement, is sometimes a bit of a challenge. So, well, let's move on. The last question here is regarding a PAGA, I believe it is PAGA how do you avoid and I don't know what that acronym means, but maybe you can talk about it. But
private attorney it's basically a private attorney general action.
Okay.
So I do the advice and counsel. So I don't represent, because I recommend all of my clients have EPL coverage. So at the point where a PAGA action is something is going to arise, that's when it gets tendered over to the carriers. But how do you avoid the PAGA actions from occurring? Follow these best practices, and like lower your risk and liability exposure by having policies in place, by following the policies, by having these best practices, by meaningfully implementing organizational change. The private attorney general actions are essentially a form of employment litigation. So when you have a claim, there's different ways that employment claims can be litigated. You could go through an administrative proceeding like a DFEH, that's your Department of Fair Housing and Employment, that's California agency. So there's different agencies that you could go through. You could file this PAGA action. So there's just a different route towards addressing an employee grievance.
Okay, well, great. That's good. I appreciate you taking the extra time here today. So I just have a few concluding remarks of another 5 minutes here. I want to thank everyone for being an ECHO member, but if you're not, ECHO holds more than 30 online educational programs per year and offers a vast array of resources for boards and HOA members. If you are not an ECHO member, please consider joining and supporting the oldest statewide association advocating for better communities and well-informed HOA boards and homeowners. To do so, simply visit our website at echo-ca.org and click on the membership tab. I have some exciting news about a new membership opportunity. ECHO is forming the California Coastal Resource Panel. This panel will address issues regarding global warming, sea rise, and policies of the California Coastal Commission. Because it will meet virtually, we hope to have representation from all reaches of the California coastline. If interested, please look for the sign-up link in the packet we will be sending out to you after this meeting. Also, we are organizing a new monthly HOA Board Members Club, exclusively for ECHO board members and recent board members. We have topics scheduled for the first six meetings of 2022. This group is led by 2 volunteer HOA board members, Miguel Sanchez and Tom Connolly. They are wonderful and experienced leaders. Please click on the sign-up sheet in the packet to become a member of this group. We currently have 35 members and it is growing. One final mention, wildfire is particularly difficult for California residents. Del Mesa Carmel HOA had their fire insurance denied this spring because their community, like many in California, is in a wildfire corridor. If you are impacted by wildfire and are interested in learning more about this struggle, Mary Rogers of Del Mesa Carmel wants to hear from you. Please look for the information sign-up sheet in your packet of post-webinar materials or contact me or Patty Curzette for more information. That concludes our planned program for today. Thank you, Jasmine, for your informative presentation. And once again, thank you to our sponsors who made this broadcast available to everyone. And of course, a special thank you to you, our participants today. ECHO appreciates all of you for investing the time to better your communities. And have a happy Thanksgiving and a wonderful holiday season.